appeal.
Right. Well, the language I would use in Rhode Island wouldn't be file and refile. It would be file and appeal or request for a hearing from the determination that's made at the first level to the next level, which is where you're asking for this trial, so to speak, or hearing in front of a referee.
Now, do you need a lawyer from the very beginning of the process of filing already, assuming that it's going to be denied, because so many seem to be these days, David?
Yeah, you know, let's talk about two things there. Initially, when the statute was passed, and as I gave you some of the language, the statute's supposed to be interpreted liberally in favor of the employee, the claimant, because we want to make sure that that person and their family has money to live on. And if there's a reason they shouldn't get it, they'll be denied. Now, as you said, it's been interpreted a little more strictly recently, given what's going on in the economy and, you know, some change maybe in politics, if you will. But certainly, the employee is got to prove a case a little bit more than they had to when I first started practicing.
Interesting. Is it always worthwhile for a lawyer to be involved in these cases? I mean, suppose we're talking about a meager amount of money, and relatively, I don't even know what meager means in this particular situation, but is there some rule of thumb about who should have a lawyer at what levels of compensation?
Well, here's the thing. The first level, in this particular instance, you do your own application. You don't need a lawyer for that. You know the facts and the situation better than anyone. Now, if you've been denied and a hearing is going to be set up in front of a referee, and as I was saying, that's where the record is sort of set. There are some opportunities to expand the record, but that's where it's really set. You want to have an attorney at that level. And interestingly enough, if you win at certain levels and the appeals go on, the state, out of the unemployment fund, pays your attorney's fees.
Oh, so it's not a matter of, gee, David, I don't know if this is worth your while. It really could be an issue that the state's going to be involved there. Okay, good to know.
But here's the thing. It depends on your success in the hearing, and many attorneys who do practice in this area are going to want some fee up front.
Really? Okay.
Because there's no guarantee that they're going to get paid from the state. It's possible that they're going to get paid.
What's the range of costs that someone might incur enlisting the help of a lawyer?
All right, again,
roughly.
I tell you, I don't do these as a matter of course anymore. I did do them, and when I was doing them, I would see typically a $500 request for a fee up front from the person, and then the understanding that if there was success and it went on for a couple of other levels, that the attorney might collect fees on top of that.
Oh, that's good to know, because it helps somebody who's viewing this now determine, based on what they're likely to have in compensation, whether it's worthwhile to do that, even to go through the trouble of approaching you. So that's valid.
But, you know, it may be more now than when I was doing it, but certainly the amount that's at risk is, you know, fairly significant, because there's a couple of things. We talked about there's a wage that you're going to get, or a payment that's based on how much you were earning and what was paid in, but that's going to go on for a number of weeks. So when you multiply that out, the amount in controversy, so to speak, can be significant. Additionally, we didn't get into this yet, but given the state of the economy, there are a number of ways of extending benefits beyond the typical amount that you would be eligible for. And if you can't obtain employment within the original period, you can get extended benefits. And there's a lot of federal money now coming in to help pay for some of that.
Yes, that's good to know too. Again, though, about who qualifies. I understand that there are many different circumstances under which someone does and does not.
Okay.
Could you explore those a little bit,
and
David?
We're going to talk about the eligibility. I'll just quickly give you the rest of the appeal process and jump into that. Well, may as well keep it in some order.
That. Okay.
All right. So you have the hearing in front of the referee.
Yes.
If you lose that, the next step would be to a board of review, which would be a 3-panel hearing board. They're supposed to follow the record that was already set at that first level, but you can introduce other evidence on occasion if there's a reason that you should be allowed to do that. If you lose at that level, then it's under the APA, which is the Administrative Procedures Act. It's an appeal from an administrative or governmental agency to the District Court of Rhode Island. And then if you lose at that level, you have another appeal to the Supreme Court. Very few of these cases actually end up going through that whole process.
And how long does this whole process, if it goes that far, how long could that actually take, David?
Well, the Board of Review hearing will come up relatively quick, because remember, we're talking about people's benefits and people going without money. If you did lose, you actually raised an interesting point. If you won and the other side appealed, they continue paying you. And if you lose at the next level, they don't get paid back. Your benefits will stop, but whatever you were paid does not get paid back. And that's why I say generally these referees should err in favor of the employee who needs money to live on. It can be reversed. You know, like I said, money's not going to get paid back, but it can be stopped relatively quickly on that appeal, relatively being a month or so.
So the appeal process wasn't really put into place to help the employer necessarily, although it can.
Mm-hmm.
I guess we all assumed that it was because the employee was routinely denied that he automatically had to go through an appeal process, but you're explaining another side of this too, which is an important one.
Well, when we say routinely denied, much less so in unemployment cases than perhaps Social Security disability cases.
Okay.
That's a much more of a routine stamp, you know, reject, reject, reject. If you're eligible, and we're going to go into that next, you're usually going to get on at that first instance. If it's clearly a layoff, you didn't separate for disqualifying reasons, you're going to get paid. So the appeal process, which is a bit streamlined so that you don't go too long, is designed for either side initially to be able to appeal. There's some rules on who can appeal after that, but it is supposed to be designed to protect the unemployed wage earner.
If your hours were reduced, do you still qualify? You've lost wages.
All right, here you go. There's 4 issues, generally speaking, for eligibility. Was the claimant an employee of somebody? Was the claimant unemployed due to a circumstance that he didn't elect to be unemployed by? And that's where the 4th step comes in. The 3rd one is you have to be available for work. And we can talk about someone who's hurt and unavailable for work, where they might be eligible for TDI, versus someone who's been laid off and could work otherwise, and making sure they're available for work. And finally, was the person disqualified for some reason, or laid off or separated for some reason that would disqualify them for eligibility. So take your first question, which was about reduced hours.
Reduced hours.
All right. Now, are you suggesting that you still have a job with the same person, but your hours were reduced?
Your hours were reduced by that company.
And is that grounds to get unemployment?
Unemployment benefits to make up the difference, or how does that work?
Well, I guess it's 2 questions. Is it grounds to make up the difference, or could you leave and say, my job has been changed?
That one's better.
Yeah, my hours are reduced, and I can't support myself on what they're now offering me. Well, it's a couple of, they're all very interesting questions, those 2 or 3. So let's talk about all of them. The first one, some companies put in place work share.
Yes.
And that would be a situation where they want to reduce your hours, but they still want you to work there, and you can collect unemployment for the reduced hours. But that has to be a program that the employer puts in place, and it has to be treated equally amongst people in the same department or area that you're working in. So if your employer does that, you can collect unemployment on the work-share program. Now, if you were working 40 hours a week and they cut you to 20, it raises a really good question. If, as a result of that, you lose your medical benefits, other benefits of full-time employment, there is case law that would suggest that those are reasonable grounds to leave your job and try to collect unemployment, because it's a change of the working conditions that you were originally hired
for.
Right. So if you did leave under those circumstances, you would have to argue that you didn't leave voluntarily and you left voluntarily under some duress, and that you therefore shouldn't come into that 4th issue of being disqualified for unemployment for having been terminated or separated